Hi, my name is Pam Palmater. Welcome back to my YouTube channel where we focus on educating the resistance and inspiring the next generation of warriors to help us protect the people and the planet. Today, we'll be breaking down the Supreme Court of Canada decision in the Mikisew case that was released just yesterday. I have to be honest, when I first saw the headline in the news, I thought it was a joke. I honestly thought that it was maybe our native comedian Tim Fontaine from Walking Eagle News just creating a headline just for fun, just for satire. But in fact, it is no joke. The Supreme Court of Canada did in fact decide that the government has no duty to consult with First Nations prior to enacting legislation that may impact their constitutionally protected Aboriginal treaty rights. To say I was shocked about this case would be an understatement. I wasn't shocked from the sense of the fact that Canadian courts regularly prescribe and minimize Indigenous rights. That happens all the time. But with regards to duty to consult First Nations before government takes actions that impact our rights, that's long settled law. I mean, we literally have 3 decades of court cases from the Supreme Court of Canada, which has said over and over and over and over again that the Crown has an obligation to consult with First Nations prior to taking any activities or approvals or making decisions that could potentially impact our rights. That's why so many of us, lawyers included, thought that this court case was going to be more about what are the parameters of the duty to consult when we're talking about legislation, as opposed to whether or not there is a duty to consult. I don't think anyone, except for federal and provincial governments, thought there was any chance that the court would say that there's no duty to consult. So in this video, I'm going to break down the core analysis from the majority of the justices from the Supreme Court and also talk about the dissent in the Supreme Court, because the dissent is actually really important and it's more in line with First Nation thinking on this case. And then I will end this video with some key takeaways and next steps for First Nations. So what is this case about? Well, here's the background. This case involves the Mikisew Cree Nation from Alberta, who are adherents to Treaty 8, and they were challenging the fact that the former Conservative Prime Minister, Stephen Harper, was trying to pass through Parliament 2 large omnibus bills. Now, omnibus bills are bills which take and make a whole bunch of amendments to a whole bunch of different pieces of legislation. And during the Harper era, his omnibus bills were giant, sometimes hundreds of pages long. And within those omnibus bills, specifically Bill C-38 and Bill C-45, Harper was literally gutting environmental protections and specifically protections for water. The Mikisew Cree Nation said that the government had a duty to consult with First Nations before they took such actions, knowing that degrading environmental protections for land and water would also degrade their ability to hunt and fish and live as Indigenous people. So, the Mikisew Cree Nation made an application to the federal court for a judicial review of the decision to pass this legislation. At the first level of court, they won. The court found in their favor that in fact there was a duty to consult with the Mikisew before passing this legislation. However, the government appealed this decision, and at the Federal Court of Appeal level, the appeal was overturned and they sided in favor with the government, saying in fact there is no duty to consult and in fact there is no possibility to have a judicial review over legislation or lawmaking. So the Mikisew appealed to the Supreme Court of Canada, where the Supreme Court of Canada dismissed their appeal. And what that means is that the Supreme Court of Canada sided with the federal court against the Mikisew Cree Nation. They did this primarily because they felt that the Federal Court Act doesn't allow an action of judicial review against the legislation or lawmaking process. However, the court didn't stop there. They went on to offer their analysis as to whether or not the duty to consult First Nations applies to governments during the lawmaking process. Unfortunately, their answer was a resounding no, but the topsy-turvy, twisted way they got to that decision is really what has the most of us scratching our heads in disbelief. So the majority of the court recognized that there is an inherent tension, to say the least, between Canada's assertion of sovereignty over our lands and territories versus our pre-existing and original sovereignty. They said it's this tension and this special relationship that requires the Crown to act honorably in all of its dealings with Indigenous peoples. They further explained that the duty to consult actually has its origins in the constitutional obligation of the Crown to act honorably in its relations with First Nations people. And they even went on to say that the whole purpose of Section 35 protection for Aboriginal rights, treaty rights, and Aboriginal title is to prevent unilateral action by the Crown that would negatively impact our rights. I mean, this is literally the whole purpose of having our rights constitutionally protected. But despite all of this reasoning, they still managed to get around to the end decision that the duty to consult simply doesn't apply to the lawmaking process. Their justification? Well, they said that Canada, under its constitution, is divided into 3 branches of government: the executive, the parliamentary or lawmaking branch, and the judicial branch. And if Canada is going to work properly, as the Constitution intended, these 3 branches of government aren't supposed to interfere with what the others are doing. They also added that, and in fact, if we tried to impose the duty to consult on Parliament during the lawmaking process, it would be too hard for them. It'd be way too much effort. So at the end of the day, they said there is no duty to consult. However, the Crown does have to act honorably. And that's how they left it. Act honorably. I'm not quite sure how you take act honorably to the bank, given Canada's entire history of acting anything but honorably. But here's why the dissent is so important. Justice Abella made some critical points that seem to be more in line with not only 3 decades of Supreme Court of Canada cases, but also the positions of First Nations and how they see the relationship. Her first major point was that she couldn't understand how the majority of the court could arrive at that determination about no duty to consult. In her words, she actually said it was untenable if you look at all of the 3 decades of jurisprudence from the very same court. And she said, in fact, that the development of legislation does trigger the duty to consult. Why? Because the duty to consult and the honor of the Crown attaches to the relationship between the Crown and Indigenous peoples in every aspect. To her mind, the duty to consult applies to all government contact that could potentially negatively impact our rights. And I agree, that seems to be what all of the previous jurisprudence has said. Justice Abella also reminded us that according to previous Supreme Court precedent, the duty to consult is to be given a generous and purposive approach, and that includes strategic and high-level decision-making, like you would find in lawmaking, for example. And at the end of the day, she also had reconciliation on her mind, because she said, what good is taking a backwards approach where government is allowed to go ahead and act whatever legislation that they want to, and then after the fact have First Nations sue them in court, have a court decide that it is unconstitutional and declare that section or that piece of legislation null and void. How does that advance reconciliation? Never mind the fact that it is a gross waste of time and resources, not just for taxpayers, but also for Indigenous peoples who are the most impoverished in this country. And she made 2 final but very profound points. One is that it is the role of the judiciary to intervene to ensure that Parliament is in fact abiding by its own constitutional authority and constitutional obligations. And she said, what is the point of having a constitution if the government gets to ignore it when it doesn't like certain parts of it? That kind of defeats the whole purpose. And I tend to agree. I think what this court case has done is literally gutted the Section 35 protections for our rights and has essentially offered us an empty shell of a constitutional promise. I mean, Section 35 was already a pretty empty box. The only things that are sitting in there are some of the limited rights that have come directly out of the Supreme Court of Canada. But the federal government and provincial governments certainly haven't been adding any rights to that box. Now we have a complete removal of the duty to consult for legislation. That makes no sense when it's legislation that has done the most amount of damage to our rights and our territories. It's through federal, provincial legislation, regulations, policies that have denied us the right to exercise our rights, denied us to the free use of our territories, has breached our treaty rights, and breached our own rights to be self-determining. I also agree with Justice Abella that this essentially gives the government a backdoor out. It means that now, any decision that they know that they would have to consult on, all they have to do is pass a piece of legislation and they don't have to consult. I don't see where the honor is in that. I don't see how that advances reconciliation. And I think it's a fundamental breach of the Section 35 protections of our rights. And we all know that Canada already has an access to justice problem, which means that the most impoverished in this country, the ones who most need access to the justice system, will be the least likely to get it. So what will happen is, if we're required to litigate against the government every time they breach our rights, it means that the vast majority of us aren't going to be able to do that. We're not going to get a remedy. And so the breaching of our rights is going to become standard practice in an even greater way than it is now. So I'm going to give you 5 important takeaways from this case. And the first one has to do with Prime Minister Trudeau himself. So Prime Minister Trudeau got elected on and has been perpetuating the myth that there is no relationship more important to him than the one with Indigenous peoples, and that he is going to advance the relationship on a nation-to-nation basis, which will have at its core the recognition and respect of our rights. So, on the one hand, he says he's about respecting rights for First Nations, and on the other hand, he's happy to let his Minister of Justice go before the Supreme Court of Canada and say, oh no, by the way, we don't have a duty to consult, we have parliamentary supremacy, we don't have to take into account any Aboriginal constitutional rights. Why would anyone trust a leader who would go behind our backs and do this counter to every single promise he made about the relationship? And I think that we should be very careful about how we view this federal legislative rights framework that Trudeau is advancing in this context. The second important takeaway has to do with Indigenous Minister of Justice Jody Wilson-Raybould herself. It was her and her Justice Council that actually advanced these arguments before the Supreme Court of Canada. Imagine our own Indigenous Minister of Justice saying there is no duty to consult with First Nations, that Parliament has supremacy, and completely ignore our Section 35 protected rights. She single-handedly helped gut Section 35 protections. Yet she's quoted as saying that this case shows that there is true reconciliation in this country. I don't know how twisted a view you have to consider this reconciliation, but I'll tell you, this is nowhere near the kind of reconciliation that the vast majority of us think is much needed in Canada. The third really important takeaway is about the Mikisew Cree Nation themselves. They put their time, their effort, their money into taking this case all the way up to the Supreme Court of Canada. They have also indicated that they're going to continue their fight to protect their treaty rights. And I think it's incumbent upon us as First Nations and social justice allies to rally behind them offer them solidarity and support in whatever way we can to make sure that their rights and our rights are all protected. And the fifth and final important takeaway from this is, despite the fact that the Supreme Court of Canada has now steered us away from the negotiation track and more towards the litigation track, it's going to be important that we as First Nations and our allies get together, organize, strategize about which cases we're going to bring forward and when, to consolidate our resources and make sure that no government continues to breach our Aboriginal and treaty rights. Thanks for watching. If you're new here, please consider subscribing to my channel, liking my video, or sharing it with your friends, family, and other social justice allies. I'll also include links in the description box below to the court case itself, an article that I wrote about the court case, and any updates that come from time to time. Thanks again for watching, and stay alert, warriors.